All right, so in this chapter, we're going to continue building our legal research toolbox, okay? And at this stage, you should already understand that legal research is not simply about finding something that's related to your issue. Legal research is about finding the right authority from the right jurisdiction at the right level of authority and then using that authority accurately, okay? That is where many new legal researchers get frustrated. They understand that cases matter. They understand that statutes matter, and they may even understand the difference between primary and secondary authority. But when they sit down to actually begin researching, they may not actually know where to start. Okay, so imagine that an attorney walks into your office and says, look, I need these cases on whether a business can be liable when a customer slips and falls on a wet floor. All right, that sounds simple enough until you begin searching. Are you researching negligence, premises liability, notice, duty, constructive knowledge, invitees, summary judgment, like what happens if the incident happens in Georgia? What if it happened in federal court applying state law? Like, what if the attorney needs binding authority and not persuasive authority? That's why finding tools matter. Okay, so in this chapter, we're looking at the three most important legal research tools, which is Digest, American Law Reports, and Words and Phrases. And each one of those tools serves a different purpose, but they all help you to locate useful legal authority. So a digest can help you it can help you find cases organized by subjects. American Law Reports, or ALR, they help you to find in depth annotations that analyze legal issues and they collect cases from different jurisdictions. Now, words and phrases help you find cases that define or interpret specific words or phrases. Okay, so one of the most useful things to remember throughout this chapter is that these tools are not usually the final authority that you're going to rely on. They're just pathways, all right? Research aids. They're going to help you get to the cases, the statutes, the rules, and other legal authority that you will eventually analyze and cite, okay? And a strong legal researcher does not just search randomly. A strong legal researcher knows which tool to use depending on the research problem. And that's the skill that we're developing here. Now, actually, before I get started, I should have added this. After reading this chapter, you should be able to describe the purpose of a digest, explain like how to use it, to summarize, how the annotated law reports are used in the research process, and even explain how to use the words and phrases. But I want to pause for a second and talk about why these objectives matter. Okay. Legal research often begins with a lot of uncertainty. All right, you may not know a controlling case, you may not know the exact legal terminology, you may not know whether or not your issue falls under one legal topic or another, and you may not know whether or not your jurisdiction has addressed your exact question. Okay, so research tools are going to help you to move from uncertainty to structure. So, for example, if you're researching a constitutional law issue, you may know, generally speaking, that the Fourth Amendment applies. All right. But Fourth Amendment, in quotations, okay, Fourth Amendment, that is a very broad research area. It's going to include search warrants, warrant exceptions, probable cause, reasonable suspicion, traffic stops, searches of homes, searches of vehicles, cell phone searches, school searches, consent searches, and a whole mess of other issues. Okay. So the digest can help you narrow that broad topic into one that is smaller and more precise with categories. Okay. ALR can help you understand how the courts across jurisdictions have discussed a recurring legal issue. And the words and phrases can help you find cases defining a term that may be critical to your analysis. So, as we go through this chapter, I want you to kind of think practically. Don't just memorize the definitions of these tools, but ask yourself, when would I use this? How could I use this? What problem does this tool solve? How would this help me as a paralegal or a law clerk or a legal studies student? Okay. And that practical mindset is going to be what helps to turn research from a guessing game into a process. Okay. Now, I no longer digress. Um, so, what is a digest? And I've already given you some of it, but a digest is a book or an index that arranges short summaries of cases by subject. Okay. These summaries are sometimes called digestive cases because they condense a legal point from a case into a brief statement. So the purpose of a digest is to help you find cases. It does not help to replace the cases itself. Again, it is a finding tool. All right. So let's compare this to something a little more familiar. Suppose you're looking for a specific recipe in a huge cookbook. You may not want to flip page by page through the entire book, and instead you might use the index. All right, if you're looking for chicken recipes, you go to chicken. If you're looking for desserts, you go to desserts. The index is not going to cook the meal for you, and it does not contain the entire recipe, but it does direct you to where the recipe can be found. Okay, and a digest works in a very similar way. So it's going to organize the case law so that you can locate cases dealing with a particular subject. All right, and the challenge with case law is that courts decide thousands of cases, and those cases involve many different issues. So one court's opinion might involve several legal issues at once. For example, let's say you have a criminal appeal. It might discuss whether the police had probable cause, whether or not the defendant's statement was voluntary, whether evidence should have been excluded, whether or not the jury had instructions that were proper, and whether or not the sentence was constitutional. A digest breaks legal issues into smaller pieces and organizes those pieces by subject. Okay, and that organization is valuable because legal research requires precision. Okay, so let's say that you're researching whether a confession was voluntary. You do not want every single criminal case involving a confession. You need cases discussing voluntariness, police interrogation, coercion, Miranda warnings, waivers, and any other kind of related issues, okay? And the digest can help you locate those cases grouped around that specific legal question. Okay, so the digest gives you a short summary and the citation to the case. Once you identify a case that appears relevant, it's then your job to retrieve the full case, to read it, analyze it, update it, and then determine whether or not it actually helps to answer your research question. And the last step is essential because the digest is only the beginning. Now, the American Digest system is associated with West Publishing. And West became known for its national reporter system, which published court opinions from different jurisdictions. But once all of those cases were being published, legal professionals needed a way to find cases that they were looking for. That is where the digest system became so important. Okay. So West's American Digest system organizes cases using a topic and a key number system. That is one of the most important legal research classification systems. All right, so a topic is a broad area of law. So examples would be like criminal law, contracts, torts, evidence, constitutional law, landlord tenant, negligence, whatever. But those topics are still too broad to be useful on their own. So within each topic, West assigns key numbers to make the legal issues more narrow. Okay, the key number is what allows you to drill down to a specific legal point. For example, under the broad topic of evidence, there may be key numbers dealing with hearsay and relevance and character evidence and expert testimony, authentication, privileges, impeachment. Under the broad topic of criminal law, there may be key numbers dealing with intent, defenses, sufficiency of evidence, jury instructions, sentencing, or searches and seizure issues, right? So the power of the system is consistency. So if a legal issue is classified under a certain topic and key number, then you can use that classification to find other cases discussing the same issue. All right. This is especially helpful when you find one good case, but you need some more. All right. Maybe you found a Georgia case, discussing constructive possession of drugs. You can now look at the topic and the key number that is assigned to that legal point and then use that same classification to find additional cases on constructive possession. Okay. Now, in modern legal research platforms, The same concept often appears digitally. So when you read a case online, you might see head notes, and those head notes often are going to connect the topics and the key numbers. So clicking on those classifications can lead you to additional cases that are discussing the same legal issues. So even if you never use a physical digest book in practice, understanding the digest system helps you to understand how legal information is organized, and it helps you to become a more intentional researcher. All right, so digests are used to help you find cases from your state, region, your jurisdiction, or the entire country on some similar point of law. And that's important because jurisdiction matters. And one of the first questions in legal research is what law even controls? Okay. So if you're working on a Georgia case that's a state law issue, then Georgia appellate cases are much more important than cases from another state. If you're working on an issue in federal court, then you need to know whether or not, U.S. Supreme Court authority controls, whether federal, circuit authority controls, or whether or not you're looking at persuasive district court decisions. So if you're researching a national trend or like a question that your jurisdiction has not answered, then cases from other jurisdictions may become useful as persuasive authority. Okay, and a digest is going to allow you to choose the scope of your research. For example, if you're looking for Georgia cases, you would start with a digest that covers Georgia. If you're looking for cases from a region, you're going to use most likely a regional digest. If you're doing a more broad national research, then you're going to use a more comprehensive digest. Okay, so this connects to a larger research strategy. You're going to start with the most relevant and controlling authority first. So don't begin by collecting cases from everywhere if your issue is governed by one single jurisdiction. Start where the answer is most likely to matter. All right, let's use a very practical example. Suppose that your attorney asks you to research whether a landlord can be liable for injuries caused by a broken staircase in an apartment complex. All right, the incident happened in Georgia. Your first instinct might be to just search, landlord broken staircase injury. That's going to produce many results, but not all of them are going to be helpful. A better approach would be to identify the relevant legal concepts like landlord tenant law, premise liability, duty to repair, notice, negligence, even something on the more local level like building code violations. Then you would use a digest to find cases categorized under those legal issues in Georgia. And the digest is going to help you to avoid drowning in irrelevant search results. It's going to direct you towards cases that are organized by legal subject. Now, digests are excellent sources for finding cases, but you may not cite them specifically as legal authority, okay? You also should not quote from a digest summary as though that was the law. All right, and that's one of the most important warnings in this particular chapter. A digest summary is not the case. Okay, it is not the court's full reasoning, it is not binding authority, it is not the final answer. A digest summary is someone else's condensed statement of one legal point from the case. That summary might be super useful, but it can also be very incomplete. Okay. It may not include the facts that made the court decide the way that it did. It may not explain procedural history. It may not tell you whether or not the case was later questioned or overruled. It may not even capture like limitations or exceptions. This is why you must always retrieve and read the full case. Okay, so just imagine that you find a digest summary that says something like store owner not liable for customer's fall where owner lacked notice of a hazard. That sounds useful, especially if you're representing a store in a slip and fall. Okay, but when you read the full case, you might learn that the hazard appeared only moments before the fall. All right, and there was video evidence showing that no employee saw it, and the plaintiff had no evidence of how long the hazard was actually there. But let's just say that your case was different. In your case, employees walked past the spill for 30 minutes. Customers complained. Nobody cleaned it up. So the digest summary alone would not show you that distinction. You would only discover it by reading the full case. Okay? And legal analysis depends heavily on facts. Two cases can sound very similar in a summary, but be very different once you read them. So the rule is use digest to locate cases, but rely on and cite the cases themselves. All right. This is also a professionalism issue. An attorney depends on accurate research. So if you give an attorney a case based on a digest summary without actually reading the case, you may miss important information, and that could weaken a legal argument or even lead to incorrect advice. So, as a legal researcher, your responsibility is not just to find sources, your responsibility is to also evaluate those sources. Now, the process for using a digest begins with identifying the correct topic name and key number. So if you don't already know the topic and key number, you can often begin with a descriptive word index. All right. Now, the descriptive word index allows you to start with words that describe your issue. It then will point you toward the topic and the key number that might apply. Okay. And that's helpful because legal vocabulary is not always obvious at the beginning of research. For example, let's say that your research problem involves a person who was injured after being attacked in a parking lot outside of an apartment complex. You might begin with words like assault, apartment, parking lot, landlord, negligent security, premises liability, or criminal acts of third parties. So the descriptive word index can help you move from those ordinary descriptions toward the legal classification used in the digest. So once you find the topic name and the key number, the next step is to locate the correct volume in the digest set. In print research, the topics are usually printed on the spines of the volumes. And you find the volume containing your topic, you go to that topic, and then you locate the specific key number. Okay? After you find the key number, you then review the case summaries that are listed under it. Those summaries will include citations to cases. Some of them might be directly relevant, others may be only loosely related. Your job is to screen them. You're not finished there though, after you check this main volume, okay? You need to also check the pocket part or the supplement. Now, in print legal research, the pocket parts are updates that are inserted into the backs of the volumes. They include newer cases and changes that occurred after the main volume was published. And that matters because the law changes. All right. A case that was current when the main volume was printed may no longer be the most recent authority. So new cases may have been decided. Older cases might be limited or overruled. So after reviewing the main volume and supplement, you retrieve the cases that look relevant. Then you read those cases carefully and you determine whether they are binding or persuasive. You update them to make sure that they are still good law. Then and only then do you use them in your legal analysis. Okay, so the checklist is really a research workflow. We're going to identify the issue. We're going to find the topic and the key number. We're going to locate the digest volume. We're going to review the case summaries. We're going to check updates, retrieve the cases, read the cases, update the cases, and analyze them all. Now, when researching, think small. Start with the smallest digest unit that you think will be helpful to you. Okay, that is a very practical tip and it can save you a lot of time. New researchers often start a little too broadly. They will search the entire country when they only need to search one state. They will search all negligence cases when they only need negligent security cases. They will search all constitutional law when they only need cases about traffic stops and reasonable suspicion. Okay? Broad searches are not always bad, but they can become overwhelming very quickly. They can also distract you from the most relevant authority. All right, so think of research like using a flashlight in a dark room. All right, if the beam is too wide, you might see everything but focus on nothing. All right. If the beam is narrow enough, you can examine the thing that actually matters. All right. For example, let's say that your attorney asks for cases on whether a person can be charged with possession of drugs found in a shared vehicle. That the broad topic there might be criminal law, but that is far too broad. Okay. The more specific issue may be constructive possession. And even more specifically, you might need cases involving constructive possession in a vehicle occupied by more than one person. So if you start with the smallest useful issue, then your research becomes more efficient. Okay. The same principle applies to geography. So if the case is in Georgia State Court, start with Georgia law. All right. If you cannot find enough Georgia authority, then you might expand to other jurisdictions, but you're going to have persuasive authority then. But don't begin with persuasive authority when binding authority might exist. All right. So thinking small doesn't mean thinking narrowly, like in a careless way. It means being strategic. So start with the most precise and relevant category and expand from there, but only if necessary. Now, West Digest have several common features that help researchers find and organize case law. The first feature is uniform classification. That means that West uses a consistent system of topics and key numbers. Now, once you identify the correct topic and key number for an issue, you can then use that classification to locate similar cases elsewhere. That is useful because legal issues repeat themselves. Okay, so courts in different jurisdictions may consider similar questions. So the classification system allows researchers to track those questions across cases. Now, the second feature is the descriptive word index. And this index, again, it helps you to find the correct topic and the key number when you're starting with ordinary language. Many research problems begin in everyday terms. So a client does not walk into a law office and say, I need assistance with constructive notice in a premise liability matter. A client says, I slipped at the store because there was water on the floor. All right. The researcher has to translate that real world problem into legal concepts. The descriptive word index helps with that particular translation. Okay. The table of cases is another feature. So like if you already know the name of the case, then the table of cases can help you to locate where that case appears in the digest system. That can help you see what legal topics and key numbers are associated with that particular case. Now the table of words and phrases. That helps researchers to locate cases that define or interpret specific words. This connects to the separate words and phrases resource that we're going to discuss in a little bit. But supplementation, this is a very critical feature. Law is not frozen in time. So this is where you have your supplements, your pocket parts, and your updates, and they help researchers to find the newer material. So in legal research, old information can be dangerous if it has not been checked out. Okay. And then cross-referencing is also important. Legal issues often overlap with one another. So a single fact pattern may involve contracts, torts, evidence, damage, procedure. Cross-references help you to move from one related issue to another. Okay. For example, let's say that you have a case involving a tenant being injured by faulty wiring. You might begin under landlord-tenant law, but cross-references are going to lead you likely to negligence, premise liability, building codes, notices, damage. Without cross references, you might miss a more careful category. But those digests and their features, they're designed to help you think like a researcher. They help you to organize the law instead of wandering through it just randomly. Now, this slide brings us back to a very key distinction. And it's about use versus citation. Okay, you use digest to find cases. You do not use them to cite authority. Okay, that distinction matters in legal writing. So whether you are writing a memorandum, a motion, a brief, or a research assignment, your legal support should come from proper authority. If the rule comes from a case, cite the case. If the rule comes from a statute, cite the statute. If the rule comes from a regulation, cite the regulation. The digest is not the rule itself, okay? Think of it more as a doorway. It's going to help you to enter the legal authority, but it's not the destination, all right? A common beginner mistake is to trust the digest summary because it seems very clear and convenient, right? But convenience is not enough in legal research. You have to verify. So after a digest leads you to a case, you should ask several questions. What court decided the case? Is that court binding in my jurisdiction? What are the facts? What issue did the court decide? What rule did the court apply? What was the holding? Has the case been overruled? Has it been reversed, questioned, distinguished? Does the case support the position that I'm researching? And only after answering those questions can you responsibly use the case. This is also why reading cases carefully matters. You are not simply hunting for quotable sentences, you are trying to understand how the court reasoned and whether that reasoning applies to your facts. Okay, so in practice, a digest may help you to build a list of possible cases, but your final research product should be based solely on the cases that you actually read and evaluated. Now, American Law Reports, again, also commonly called ALR, they publish select appellate court decisions along with comprehensive and objective essays related to legal issues raised in those cases. Now, ALR is different from a digest. A digest is usually brief and highly organized by topic and key number. The ALR is explanatory, so it's going to give you annotations which are detailed discussions of legal issues. So an ALR annotation may collect cases from many jurisdictions and explain how courts have handled a specific legal question. That can be extremely useful when you need more than a case list, okay? Sometimes you need to understand the legal landscape. So let's say that you're researching like whether a parent can be held liable for a child's harmful conduct. That issue may vary regarding jurisdiction. Some states may have statutes, some courts may have, applied common law negligence principles. Some may distinguish between intentional acts and negligent supervision, but an ALR annotation is going to collect those approaches and organize the cases for you. Okay. Or suppose that you're researching like whether emotional distress damages are available when a person witnesses injury to a family member. That issue may also involve different rules in different states, including things like physical impact rules, zones of danger rules, bystander recovery rules, and even limitations based on relationship or proximity. The ALR can help you to see those categories. So this makes the ALR especially useful when you're researching an issue that is unfamiliar or complex or treated differently across jurisdictions. However, okay, the ALR is still not a substitute for reading the primary authority. The annotation can teach you about the issue and lead you to cases, but you still need to retrieve and analyze the cases that matter for your specific jurisdiction. Now, ALR annotations are used to read these comprehensive analysis of legal topics and to locate the primary and secondary sources. One reason ALR is valuable is that it often does some of the organizational work that researchers otherwise have to do from scratch. So an annotation may explain the general rule. It can identify exceptions, compare jurisdictions, and discuss factual distinctions. For example, um, uh, imagine that you are asked to research like whether a hotel has a duty to protect guests from criminal acts by third parties. That question could involve premises liability, foreseeability, negligent security, prior similar incidents, duty, causation, and public policy. So if you start with a broad search, you may find hundreds of cases and not have a clue on how to organize them. Okay. An ALR annotation may organize the issue for you. It may separate cases where courts found a duty from cases where courts did not. It may also explain that some courts focus on prior similar crimes while others apply a more broad foreseeability test. Okay? And it can also identify leading cases and point you to related sources. This is all very helpful for legal writing because legal analysis often requires comparison. So you may need to explain that your facts are similar to one line of cases, but different from another. Okay, and the ALR can help you to identify those lines of cases. Now, the ALR annotations, they also can lead you to other research sources, including your statutes, your legal encyclopedias, your treatises, your law review articles, additional cases, all those things. So that makes the ALR a useful bridge between secondary authority and primary authority. But you have to be careful because an annotation may summarize the law, but you still need to confirm the law in your actual jurisdiction. Okay, so you need to make sure that your cases are current. Remember, legal research is never complete until you update your authority. Now, the ALR has several features that researchers that helps them to navigate the material. Okay, first, it includes the cases. These are your selected appellate court decisions connected to the legal issue that's being discussed. Those cases often serve as a starting point for annotation. Okay. Second is going to be the annotations. This is the detailed essay that analyzes the actual issue. This is where you're going to find discussion, organization, references to cases, and they're all likely coming from different jurisdictions. Third is you have the research references. Now, these references may direct you to related annotations, legal encyclopedias, treatises, statutes, law review articles, and other materials that are going to be helpful for you to continue researching. The outline, I think it's especially helpful. And it's because some annotations are long and detailed. So the outline allows you to kind of see the structure of the discussion and jump to the section that matches your research question. All right, the index, it's going to help you to locate annotations by subject, and that's useful when you are beginning with a topic and you need to find whether the ALR has covered it. The table of cases, laws, and rules, this helps you to identify authorities discussed in the annotation. So if you're looking for a specific case or statute, that table can help you find where it appears. Okay, now the scope note, this is very important. It's going to explain what the annotation covers, and that can save you time. All right, so before you rely on an annotation, you need to know whether it actually addresses your issue. All right, sometimes an annotation may look relevant based on the title, but the scope note reveals that it covers only a narrower or different issue. Okay. The background in the summary section, it gives you a general overview before you move into the detailed analysis, and that can be useful when you're new to a topic. So when using the ALR, work with the structure. Don't just skim it randomly. Start with the title and the scope note. Review the outline, read the background and summary, and then move to the sections that most closely match your issue. From there, identify the cases that you need to retrieve and read, okay? Again, ALR, it can be a very powerful research tool, but you have to use it actively and critically. Now, words and phrases is a research tool that provides definitions of words and phrases as interpreted by the court. It's going to include interpretations dating back many years, and it's going to cover both legal terms and ordinary words. Now, this tool matters because lawsuits often turn on the meaning of language. So sometimes the word is obviously legal. For example, probable cause, reasonable suspicion, custody, malice, consideration, negligence, possession, hearsay. These all have legal meanings that might differ from everyday understanding, okay? Now, other times the word may seem ordinary until it becomes an important part of a legal dispute. Okay, words like residence, vehicle, employee, family, reasonable, substantial, material, willful, dangerous, all of those things can become central to a case. So, for example, suppose you have a statute that applies to somebody's residence. What does residence even mean? Does it mean where the person sleeps at night? Where the person intends to remain? Where the person receives mail? Where the person's registered to vote? And that answer might depend on the legal context, okay? Or suppose that you have a criminal statute that uses the word possession. Does possession require the item to be physically on the person? Or can it be someone, possesses something that's located nearby if they know about it and have control over it? Courts have interpreted possession in many contexts, and words and phrases can help you to locate those cases. So that tool is especially useful in statutory interpretation, contract interpretation, criminal law, property law, family law, employment law, and even procedural issues. But the key idea is that the legal meaning is often shaped by the judicial interpretation. So words and phrases are going to help you to find cases where the court has already done that interpretive work. And last but not least, um, you use words and phrases to find cases that have interpreted or defined specific terms, words, or phrases, right? And these may be technical legal terms or everyday words that matter in a legal dispute. Let's imagine that you're researching a statute that requires, quote unquote, reasonable efforts. That phrase sounds very simple, but legally it may raise several questions. What counts as reasonable? How many attempts is required? Does the person have to document those efforts? Does the meaning change, depending on the context? Words and phrases can help you to locate cases where courts have interpreted these reasonable efforts. Okay? Or imagine that you have a contract dispute that's involving the phrase material breach. The parties may disagree about whether one party's failure was serious enough to excuse the other party's performance. Words and phrases can help you to find cases defining what is a material breach, and they will explain how the courts evaluate it. All right. Another example is the phrase in custody. In criminal procedure, custody can matter for Miranda purposes. So a person may not be formally arrested, but the circumstances may be restrictive enough that the court considers the person in custody. Words and phrases can help you to locate the cases interpreting that phrase. All right. So when using this tool, remember that the same rule applies as with Digest and ALR. The tool is just helping you find the cases, but you still have to read it yourself. All right. A definition is only as useful if it applies to your context itself. Okay. A court's definition of residence in one, say a tax case may not be the same as in a family law case. A definition of an employee under one statute may not apply under another. Definition of possession in a criminal case may not apply in a property dispute. Context matters. So always ask, what was the legal issue? What statute, what rule, what doctrine, whatever. What was the court interpreting? What facts influence the court's decision? Is the case binding or persuasive? And is it still good law? Words and phrases is especially helpful when your research question depends on the meaning of language. And it can help you to avoid assuming that a word means what it means in ordinary conversation. In law, words often carry specific meanings shaped by courts over time. Okay. Now, just kind of in closing, the major takeaway from this chapter is that the legal research tools, they do have different purposes. Again, Digest help you find cases. They're especially useful when you need case law on a specific legal issue and you want to locate cases organized by the topic and key number. The American Law Reports is going to help you understand those more broad legal issues through those detailed annotations. It's especially useful when you need background or you need some sort of comparison among jurisdictions, a national perspective, or even like a collection of cases on a recurring legal question. And words and phrases are going to help you define cases or interpret particular words and phrases. Okay, and it's especially useful when the meaning of a term affects the outcome of a legal issue. All three of these will help you to locate authority, but none of them is going to eliminate the need for legal analysis. And I cannot stress that enough. Okay. As a legal researcher, you have to move beyond simply finding a source. You have to evaluate it. You have to know whether or not it's primary or secondary authority. You need to know whether it's binding or it's persuasive. You need to know whether it's current. You need to know whether the facts and the reasoning actually apply to your issue. That is the difference between searching and researching. Searching means just finding the results. Researching means finding the right results, understanding them, checking them, and then applying them accurately. So as you work with those tools, keep a few things in mind, okay? Again, start with the smallest useful research area. If Georgia law controls, start with Georgia. If a narrow legal issue controls, start with the narrow issue. Use digest to find cases, but do not cite the digest. Use ALR to understand and organize legal issues, but confirm the law in your jurisdiction. Use the words and phrases when the definition matters, but again, always read the cases in context. The goal is not to just know that these tools exist. The goal is to know when to use them, and how to move from research tool to actual legal authority. And that's what makes legal research, careful, professional, and useful. And that's all I have for you. So let me know if you have any questions. Bye.